I get a lot of questions, and I thought I would start to answer some. Hopefully, you'll find them helpful. You can also suggest questions and send them to me. I'll be glad to answer them. Uh, One of the most common questions I think I get is, do I really need to file a patent? I've got a great idea, I've got a good invention, I want to sell it. Do I need to file a patent? I heard that you can, write down all your information and put it in an envelope and seal it and mail it to yourself and make sure you postmark it, get a postmark on it, and don't open the letter so they can see it's never been opened. And won't that protect me? I think they used to call that like the poor man's patent. Well, the laws have changed. That used to be somewhat effective. It was never extremely effective, but it was somewhat effective when the United States was first to invent. Now, first to invent means that even if somebody filed a patent application ahead of you, if you could prove that you had invented it earlier, you could go to court and they could award you the patent and take it away from the person who actually applied before you. That's changed. The United States was one of the last countries to maintain that, and in order to join the ranks of patent-wide protection, which worldwide protection, we went ahead and joined with the first to file. So you get it's sometimes called a race to the patent office. So, and a lot of people feel like they'll file for a patent application and they'll find out that somebody else has a patent application and they stole it from me or whatever. It's amazing how many times two different people, totally unrelated, two or three sometimes, will actually start working on the same thing. Might be nothing happening in the art for 50 years, and all of a sudden three people are working on it and file patent applications. So it's a little kismet there. Anyway, what can you do? Why do you need? Do you need a patent? First off, you don't need a patent. Clearly, many inventions are sold with no patent pending, no patent protection, and that's fine. As a matter of fact, inventions that are more fad-like, you want to hit while the iron is hot, strike while the iron is hot, and because patents take a long time. They're taking 2, 3, 4 years, on average to get a patent right now. So if you've got something that's going to come and go, you might absolutely have to rely on just getting it to the market quick as you can. The danger, the risk of not filing a patent is that you could put it out there, you do all that work, you bring it to market, you're selling it, somebody looks at it and buys one maybe from you, or just looks it over, and they say, I can do that cheaper, I can do it better, and they go ahead and they compete. Next thing you know, 6 months later, there it is out on the market for cheaper than what you made it. And there's nothing illegal about that. It's just life, and that's what a patent protects you from. If you can get a patent, a utility patent on it, you could stop them if they did that from doing it for a certain amount of time. And right now, that can change, but it's 20 years from the time that you first file your utility application. So I hope that explains some of that to you. I'd be glad to go into more detail, and I'll probably do some more videos in the future explaining that in a little bit more detail. And also the kinds of patents that there are. There's basically a few different types, and some people want to know what they should file. So great to talk to you. Hopefully you'll comment and let me know what you'd like to hear, and I'll do my best to answer them in a straightforward way. Just to introduce myself, I should have probably done this at the beginning. My name is Mark Torche. I've been a patent attorney for about 15 years. Worked for some big law firms, Manhattan and Florida. I really branched out. My dad was an inventor, and he had some things stolen from him, and I was quite, I remember growing up with that being talked about often. So I really wanted to work with private inventors, small inventors. And the big firms were not really focused on that. I mean, we had a few, but we were really focused on industry and big patents, big companies that do a lot of patent work. And I enjoy working with private inventors and trying to explain the system to them. So that's why I branched out. I have my own firm, just me, solo, and my wife is the office manager. She does a lot of great work here too. Any of the administrative details she takes care of, and billing and all of that stuff. So I do the patent work, trademark work. Strictly practice with the in the United States Patent and Trademark Office. Don't do any other legal work. So glad to hear from you, and talk with you later.